Revocable living trust. What happens to your house, mortgage, taxes, and probate? What actually happens to your house when you put it into a revocable living trust? Does your mortgage suddenly become due? Do your property taxes change? What happens to your homeowner's insurance? And most importantly, can putting your home into a trust help your family avoid probate when you pass away? These are important questions, especially for homeowners who are approaching retirement or already retired. Today, we're going to walk through a simple example involving a homeowner named William. William owns his home, still has a mortgage, and wants to continue living in and controlling his house for the rest of his life. But when William passes away, he wants his daughter to receive the house. Instead of giving the house to his daughter today, William is considering placing the property into a revocable living trust. Let's talk about what that could mean. Welcome back to Money Smart Basics. My name is Alfonso Brooksbay. On this channel, we talk about retirement, social security, estate planning, managing your money, and the financial decisions that can affect you and your family before and during retirement. If you enjoy these conversations, remember to like this video and subscribe to Money Smart Basics. And I have a question for you. If you could make it easier for your children to receive your home after you're gone, would you consider putting your house into a trust? Think about your answer as we go through today's discussion. Let's start with the biggest question. What is William trying to accomplish? Imagine William has owned his house for many years. Maybe he bought it 20 or 30 years ago. He raised his family there. He has memories there. And although he may still owe some money on the mortgage, the house could represent one of the largest assets he owns. William doesn't want to give his house away today. He wants to continue living there. He wants to maintain control over the property. But William also knows exactly what he wants to happen when he dies. He wants his daughter to receive the house. One possible estate planning strategy is a revocable living trust. The basic idea could look like this. William owns the house today. The house is transferred into William's revocable living trust. William continues benefiting from and controlling the property during his lifetime. When William passes away, the successor trustee follows the instructions in William's trust. If the trust says the house goes to William's daughter, the trustee can then transfer the property according to those instructions. That's very different from William simply giving the house to his daughter today. Who controls the house? This is one of the first concerns many homeowners have. They hear the word trust and think, if I put my house in a trust, am I giving my house away? Not necessarily. With a typical revocable living trust, William could be the person establishing the trust, commonly called the grantor or settlor. William could also serve as the initial trustee, and William could remain the beneficiary during his lifetime. In simple terms, William could continue controlling and benefiting from his home. The trust would also name a successor trustee. For example, William might choose someone he trusts to become successor trustee if he becomes unable to manage the trust or after he passes away. That successor trustee doesn't automatically own William's house personally. The trustee has a responsibility to follow the instructions contained in the trust. That's an important distinction. What happens to the mortgage? Now, here's the question that scares a lot of homeowners. What happens to my mortgage if I transfer my house into my revocable living trust? Generally, transferring a qualifying owner-occupied home into a properly structured revocable living trust does not automatically mean the mortgage must be paid off. Federal law provides protections involving certain transfers into an inter vivos trust when the borrower remains a beneficiary and the transfer does not change the borrower's occupancy rights. So, if William transfers the house into his revocable living trust, but continues living there and remains the beneficiary, the mortgage may generally continue. William keeps making the payments. The lender's lien remains attached to the property. The trust does not erase the mortgage. If William owes $100,000 before the transfer, putting the house into the trust doesn't magically eliminate that $100,000 debt. The mortgage is still there. And this is why the actual mortgage documents and the proposed trust transfer should be reviewed before anything is recorded. What about property taxes? Next question. If my house goes into a trust, do my property taxes disappear? No. Property taxes don't simply disappear because the home has been placed into a revocable trust. William would still be responsible for the applicable property taxes. There is another issue homeowners should think about, especially here in Maryland. If William currently receives a homestead property tax credit or another property tax benefit connected to the house being his principal residence, the ownership change needs to be handled correctly. The goal isn't just to put the house into the trust. The goal is to put the house into the trust without accidentally creating another problem. That's why the deed, trust, and property tax records need to work together. Don't forget homeowners insurance. Here's something people can easily overlook: homeowners insurance. Imagine William signs all the documents, records the deed, and puts the house into the trust. But nobody contacts the homeowners insurance company. Now the title arrangement has changed, but the insurance company hasn't been informed. That's something you don't want to discover after a major insurance claim. The insurance company should be informed about the trust ownership. Depending on the insurance carrier, the trust or trustee may need to be listed appropriately on the homeowner's policy. The important point is simple. The deed, mortgage, and insurance should all reflect a properly coordinated estate plan. The trust document alone isn't enough. This may be one of the most important parts of today's video. Simply creating a revocable living trust does not necessarily mean your house is in the trust. Let me say that again. You can have a beautifully prepared trust sitting in a drawer, but if the house was never properly transferred into it, you may not accomplish what you intended. For real estate, a new deed generally needs to be prepared and properly recorded. In William's example, ownership can move from William individually to William as trustee of his revocable living trust. That process is commonly referred to as funding the trust. This is where professional preparation becomes especially important. A mistake in a deed can create title problems that may not be discovered until years later. What happens when William dies? Now we get to the main reason William considered the trust in the first place. Let's say William's house was properly transferred into his revocable living trust. William continues living there for years. Eventually, William passes away. What happens next? The successor trustee named in William's trust steps into the trustee position, according to the terms of the trust. The successor trustee then follows William's instructions. If William's trust says, "After my death, I want my daughter to receive my house," the trustee can administer and transfer the property according to those instructions. And here's the important part. Because the house was owned through the trust, rather than solely in William's individual name when he died, the house generally would not be part of his probate estate. That can make a significant difference for the family. Does a trust eliminate all probate? Here's another misconception. I created a trust so nothing I own can ever go through probate. That's not necessarily true. A trust generally avoids probate for assets that were properly placed into the trust. Suppose William puts his house into the trust, but leaves another piece of individually owned real estate outside of the trust. That other property could potentially present a probate issue. The same concept can apply to other individually owned assets that don't otherwise have beneficiary or survivorship arrangements. That's why estate planning isn't simply about signing one document. It's about making sure your assets and your estate planning documents work together. What happens to the mortgage after death? Let's go back to William. Suppose William dies and there is still $50,000 owed on his mortgage. Does the mortgage disappear? No. The trust doesn't erase the lender's lien. The remaining mortgage still has to be addressed. Depending on the circumstances, the daughter might keep the house while the mortgage is handled under applicable law. The loan might eventually be refinanced or paid off, or the property could be sold. The exact outcome depends on the mortgage, the trust, applicable law, and what William instructed the trustee to do. That's why the trust should anticipate the possibility that a mortgage could still exist when William passes away. Why not just give the house to the daughter today? This brings us to an important question. If William ultimately wants his daughter to own the house anyway, why not simply put her on the deed today? Because those are two very different financial and estate planning decisions. If William transfers ownership to his daughter now, he could be giving up some control over the property. There may also be gift tax reporting considerations. creditor concerns, family circumstances, and potential income tax consequences. On the other hand, if William retains the property through a properly structured revocable living trust, and the daughter receives it after William's death, the tax treatment can be very different. Inherited property may receive a basis adjustment at death under federal tax law. That can become extremely important if the daughter eventually sells the property. This is one reason you shouldn't automatically assume that giving your children the house today is better than allowing them to inherit it later. Conclusion. Let's bring everything together. William's objective is straightforward. He wants to continue living in and controlling his house. He wants his mortgage, property taxes, and homeowners insurance properly maintained. And when he passes away, he wants his daughter to receive the house with as little unnecessary complication as possible. A properly structured and funded revocable living trust may help accomplish those goals. But remember, creating the trust is only one part of the process. The deed has to be handled correctly. The mortgage needs to be considered. The homeowner's insurance company needs the appropriate information. Property tax considerations need to be addressed. The successor trustee needs to be clearly identified, and the trust needs to clearly explain what happens to the house after death. Most importantly, the plan should reflect what the homeowner actually wants. CTA. Now I want to hear from you. Would you rather have your house go through your estate and probate, or would you consider using a revocable living trust to make the transition easier for your family? Leave your thoughts in the comments below. And if you'd like to see another Money Smart Basics video explaining the difference between a revocable living trust, a will, a transfer on death deed, and simply adding your child to the deed, let me know in the comments. Remember to like this video, subscribe to Money Smart Basics, and share this video with someone who owns a home and is starting to think seriously about estate planning. This is Alfonso Brooks Bay with Money Smart Basics. Thank you for watching, and I'll see you in the next video. Disclaimer: this video is for general educational and informational purposes only and should not be considered legal, tax, financial, insurance, or estate planning advice. Estate planning laws and individual circumstances vary. Before creating a trust, transferring real estate, changing a deed, or making decisions involving a mortgage or power of attorney, consider consulting a qualified attorney, tax professional, financial professional, insurance provider, and other appropriate professionals familiar with your individual circumstances and the laws of your state.